A stand your ground law, sometimes called line in the sand or no duty to retreat law, is a justification in a criminal case, whereby defendants can stand their ground and use force without retreating, in order to protect and defend themselves or others against threats or perceived threats. An example is where there is no duty to retreat from any place where they have a lawful right to be, and that they may use any level of force if they reasonably believe the threat rises to the level of being an imminent and immediate threat of serious bodily harm or death. One case describes the stand your ground law. A person has a right to expect absolute safety in a place they have a right to be, and may use deadly force to repel an unlawful intruder. Justification using stand your ground laws may be limited in that the justification cannot be used in some cases where defendant was engaged in other illegal conduct at the time, when was engaged in illegal activities and not entitled to benefit from provisions of the stand your ground law. This Castle Doctrine gives immunity from liability to individuals, that is, there is no duty to retreat when an intruder enters their home. Of these, 22 jurisdictions have also extended the immunity to other locations, some extending it to anywhere where a person may legally be. Other restrictions may still exist, however. For example, a person carrying a firearm or other weapon in public, whether concealed or openly, must do so in a legal manner. The states that have legislatively adopted stand your ground laws are Alabama, Alaska, Arizona, Florida, Georgia, Indiana, Iowa, Kansas, Kentucky, Louisiana, Michigan, Mississippi, Missouri, Montana, Nevada, New Hampshire, North Carolina. Stand your ground law NCGS 1451.3, North Dakota, Ohio, Oklahoma, Pennsylvania, South Carolina, South Dakota, Tennessee, Texas, Utah, West Virginia, Wisconsin. The states that have adopted stand your ground in practice, either through case law/precedent, jury instructions or by other means, are California, Colorado, Idaho, Illinois, New Mexico, Oregon, Virginia, and Washington. For example, Michigan's stand your ground law, MCL 780.972, provides that an individual who has not or is not engaged in the commission of a crime at the time he or she uses deadly force may use deadly force against another individual anywhere he or she has the legal right to be, with no duty to retreat if the individual honestly and reasonably believes that the use of deadly force is necessary to prevent the imminent death, great bodily harm, or sexual assault of himself or another individual. Stand your ground laws are frequently criticized and called shoot first laws by critics, including the Brady campaign to prevent gun violence. In Florida, self-defense claims tripled in the years following enactment. The law's critics argue that Florida's law makes it very difficult to prosecute cases against individuals who shoot others and then claim self-defense. The shooter can argue that he felt threatened, and in most cases, the only witness who could have argued otherwise is the deceased. Before passage of the law, Miami Police Chief John F. Timoney called the law unnecessary and dangerous, and that whether it's trick-or-treaters or kids playing in the yard of someone who doesn't want them there or some drunk guy stumbling into the wrong house, you're encouraging people to possibly use deadly physical force where it shouldn't be used. In Florida, a task force examining the law heard testimony that the law is confusing. Those testifying to the task force include Buddy Jacobs, a lawyer representing the Florida Prosecuting Attorneys Association. Jacobs recommended the law's repeal, feeling that modifying the law would not fix its problems. Florida Governor Rick Scott plans his own investigation into the law. In a July 16, 2013 speech in the wake of the jury verdict acquitting George Zimmerman of charges stemming from the shooting death of Trayvon Martin, Attorney General Eric Holder criticized stand your ground laws as senselessly expand the concept of self-defense and sow dangerous conflict in our neighborhoods. The defendant, George Zimmerman, claims he was restrained at the time of the shooting, thus allowing no option for retreat and making stand your ground irrelevant to the case. Florida's legislature is currently considering a bill that would allow people to show a gun or fire a warning shot during a confrontation without drawing a lengthy prison sentence. Some research shows that racial prejudices, whether explicit or unconscious, that affect those who people consider to be violent, end up disproportionately affecting marginalized populations such as black men. As the principle makes it easier to justify lethal force based on assumptions of danger, because the availability of a safe retreat option no longer has to be considered, they have a particularly negative impact on minorities who are stigmatized as dangerous. Research into how race affects outcomes of stand your ground cases has resulted in mixed answers, with some sources claiming significant racial disparity, while others find no bias. A Texas A&M study found that when whites use the stand your ground defense against black attackers, they are more successful than when blacks use the defense against white attackers. A paper from the Urban Institute, which analyzed FBI data, found that in stand your ground states, the use of the defense by whites in the shooting of a black person is found to be justifiable 17% of the time, while the defense when used by blacks in the shooting of a white person is successful 1% of the time. In non-stand your ground states, the shooting of a black person by a white is found justified approximately 9% of the time, while the shooting of a white person by a black is found justified approximately 1% of the time. According to the Urban Institute, in stand your ground states, white on black homicides are 354% more likely to be ruled justified than white on white homicides. The paper's author noted that the data used do not detail the circumstances of the shooting, which could be a source of the disparity. They also noted that the total number of shootings in the FBI dataset of black victims by whites was 25. A 2015 study found that cases with white victims are 2 times more likely to result in convictions under these laws than cases with black victims. In 2012, in response to the Trayvon Martin case, the Tampa Bay Times compiled a report on the application of stand your ground, and also created a database of cases where defendants sought to invoke the law. However, their report, contrary to those cited above, found no difference in Florida cases in the way in which defendants claiming self-defense under the law are treated regardless of race, with white subjects being charged and convicted at the same rate as black subjects, and results of mixed-race cases were similar for both white victims of black attackers and black victims of white attackers. Shooters of black attackers overall were more successful at using the law than shooters of white attackers, regardless of the race of the victim claiming self-defense, but analysis showed that black attackers were also more likely to be armed and to be involved in committing a crime, such as burglary, when shot. The law's effect on crime rates is disputed between supporters and critics of the laws. Justifiable homicides have been found to have increased by 8% in states with stand your ground laws. Economist John Lott says that states adopting stand your ground/castle doctrine laws reduce murder rates by 9% and overall violent crime by 11%, and that occurs even after accounting for a range of other factors such as national crime trends, law enforcement variables, arrest, execution, and imprisonment rates, income and poverty measures, demographic changes, and the national average changes in crime rates from year to year and average differences across states. One study found that the adoption of stand your ground laws caused a statistically significant increase in the raw homicide rate, and had only a very small positive effect on deterrence of crime. The authors of the study were unable to determine what percentage of the increase was justifiable homicide, due to the reporting of homicide to the FBI often lacking notation whether the homicide was justifiable or not. Another analysis of stand your ground laws by economists at Georgia State University, using monthly data from the U.S. Vital Statistics, found a significant increase in homicide and injury of whites, especially white males. They also analyzed data from the Healthcare Utilization Project, which revealed significantly increased rates of emergency room visits and hospital discharges related to gun injuries in states which enacted these laws. In a 2007 National District Attorneys Association symposium, numerous concerns were voiced that the law could increase crime. This included criminals using the law as a defense for their crimes, more people carrying guns, and that people would not feel safe if they felt that anyone could use deadly force in a conflict. The report also noted that the misinterpretation of clues could result in use of deadly force when there was, in fact, no danger. The report specifically notes that racial and ethnic minorities could be at greater risk because of negative stereotypes. Florida's Stand Your Ground law went into effect on October 1, 2005. Florida State Representative Dennis Baxley, an author of the law, said that the violent crime rate has dropped since the enactment of the law, though he said there may be many reasons for the change. Others have argued that the law may lead to an increase in crime. Violent crime data for 1995 to 2015 has been published by the Florida Department of Law Enforcement. In 2012, a study was published which found that after the Joe Horn shooting controversy in 2007 publicized Texas's Stand Your Ground law, burglaries decreased significantly in Houston, but not in Dallas, over a 20-month period. A 2013 study in the Journal of Human Resources claims that Stand Your Ground laws in states across the U.S. contribute to 600 additional homicides a year. According to Mark Uestra, co-author of the study, we asked what happened to homicide rates in states that passed these laws between 2000 and 2010, compared to other states over the same time period. We found that homicide rates in states with a version of the Stand Your Ground law increased by an average of 8% over states without it, which translates to roughly 600 additional homicides per year. These homicides are classified by police as criminal homicides, not as justifiable homicides. A 2015 study found that the adoption of Oklahoma's Stand Your Ground law was associated with a decrease in residential burglaries, but also that the law had the unintended consequence of increasing the number of non-residential burglaries. In 2016, Mark G. has published a study that found that Stand Your Ground laws were not associated with lower crime rates. A widely reported 2016 study in the Journal of the American Medical Association compared homicide rates in Florida following the passage of its Stand Your Ground self-defense law to the rates in 4 control states, New Jersey, New York, Ohio and Virginia, which have no similar laws. It found that the law was associated with a 24.4% increase in homicide and a 31.6% increase in firearm-related homicide, but no change in rates of suicide or suicide by firearm, between 2005 and 2014. It noted that circumstances unique to Florida may have contributed to our findings, including those that we could not identify, and our study examined the effect of the Florida law on homicide and homicide by firearm, not on crime and public safety. The study was criticized by gun rights advocate John Lott's Crime Prevention Research Center for studying only one state. Gun enthusiast and attorney Andrew Branca, writing in National Review, criticized the study for not distinguishing between justifiable homicides and murder, and for relying solely on statutory laws while overlooking case law, that is Virginia, in determining the data set. The study was praised by Duke University professor Jeffrey Swanson for its use of other states as controls, saying, "Hey, look at comparable trends in states that didn't pass the law and don't see the effect."